We have another incredible panel here. And our fearless moderator for this panel is Vic Moss. And he is one of the leaders of the Drone Service Providers Alliance. Over to you, Vic. Thank you so much.
Good evening. Boy, we lost a lot of people. I think we'll blame it on Kenji.
Whoa, we lost John.
That's right. John left and everybody's out there to try to get him to listen to him talk some more. This is welcome to the, what are we calling this? This is a safeguard privacy in the age of advancing tech. First thing I'm going to do is introduce the guests, the other panelists here, and then we'll go ahead and let them talk a little bit. We have Mark McKinnon, partner with Fox Rothschild, Cameron Chell, President and CEO of Draganfly, Kenji Sugahara, my boss at Drone Service Provider Alliance, and Mary Caitlin Ray, Counsel, Crowell, Mooring LLC, sorry. Why don't you all take just a couple minutes, and who has the mic? I do.
My name is Cameron Chell, and I'm lucky enough to be the CEO of a company called Draganfly. We're a manufacturer and service provider in the drone industry.
Hello, everybody. My name is Kenji Sugahara. I'm the president and CEO of the Drone Service Provider Alliance. And for those folks out there, you might have heard I am now the Director of Aviation for the state of Oregon. I am not speaking on behalf of the state of Oregon, nor am I authorized to speak on behalf of the state of Oregon for this. Thank you.
My name is Mark McKinnon. I'm a partner at Fox Rothschild. I've been practicing aviation law for 33 years exclusively now. I do a lot of work in both manned and unmanned aircraft and basically all aspects that affect the aviation industry.
Hi, I'm Mary Caitlin Ray. I'm a counsel at Crowell and Mooring in Washington, D.C., and I'm thrilled to be back at Law Tech Connect for another year. My practice mainly focuses on regulatory and transactional matters that involve emerging aviation technologies, as well as we also have a fairly large general and business aviation practice involving sales, purchasing, leasing, and operation of business jets and general aviation aircraft, and also do a fair amount of M&A in the emerging aviation technology space. Before I joined Crowell, I was with the FAA's Office of the Chief Counsel for about 5 years, where I was the primary commercial attorney advising the UAS integration pilot program.
Perfect, thank you. So safeguarding privacy in the age of advanced tech. If we think the UAS industry moves fast, think about the AI industry and all of that, the last 6 months it's gone crazy. And privacy is becoming a big, huge issue with everybody involved. We hear it from the people, the city council members who basically ran for city council so they can get the sidewalks fixed. They have no idea about privacy or drones or anything like that. So we have to deal with that all the way up to the NTAI, FAA, FCC, DHS, all that stuff too. Whether it's peeping Tom laws, whether it's data collection, any of that stuff, privacy is going to be a big issue, and it's going to be even more so as we get further along. Let's start with a low-level look at what exactly we're talking about. And Cam, can you give us a layman OEM perspective of what privacy is and where it's going?
Yeah, this will definitely be the layman. I'm not the lawyer up here for sure. What is it and where's it going? Well, it's probably self-explanatory, what privacy is, but certainly as it relates to drones, it's an entire new area that's opening up. And where it's going is I personally believe there's a framework in place already that addresses many of these issues. We just need to put into practice the use cases that come up and test that framework. I do think that the drone industry will push privacy, but quite frankly, probably not more than it's already been pushed, which is probably a counterintuitive aspect of what most people are thinking. But if we think of what's already happened in the digital age with social media and the privacy that we've given up and the privacy that we've chosen to give up in many cases for the safety of everybody, I don't think we're going to push beyond that. It's just that there's this new mode or this new mechanism or this new way of us seeing it where it feels a bit more intrusive because it's physical, where digital is, it's on your phone and it's your data. And so it's kind of feels a bit removed. But when you've got a drone in front of you, or you've been in the presence of a drone and there was visual video or stuff like that, it just feels more it feels more intense. So I'm a little less alarmist around it because I'm already to the point where our privacy is basically given up. But we do have a good construct in place in order to manage those privacy issues.
Perfect. Kenji, can you give us a little bit of the operator's perspective on what we have to deal with?
Yeah, absolutely. What's really interesting these days now is privacy spans a lot of different types of operations. If you think about it, there's a lot of small operators out there who do your real estate photos, who do your local videos, scaling all the way up to the large operations that we're starting to see, especially with drone deliveries coming on board. You're starting to see a lot of long line infrastructure inspection. You're seeing a lot of different types of activities that were never done before. And what's really important is that privacy policies are critical and have to be custom tailored or tailored appropriately for the type of operation that you're looking at. So whether you're creating privacy policies, you have to look at the community, because in each of the communities, privacy is an important thing. We just wrapped up finishing Task Group 15 on the Advanced Aviation Advisory Committee. I was the chair of that, and one of the constructs that we put forth was you need to address privacy. For us to be accepted by society at large, you need to address it head on. And if there's an issue, you need to address it and address it well, because otherwise we're not going to be able to conduct operations. So from an operator's perspective, it's just having that privacy, acknowledging it. We have to do it, because I don't think we've done it well enough, because otherwise we're dead in the water. Especially when you're talking with congressional folks, legislative folks, we need to put our best foot forward.
Even though Kenji is a lawyer, I'm going to go ahead and you just passed it anyway to Mark. So Mark, at the federal level, there are, well, we could go all day on that, but Jonathan took all our time, so we can't. Does federal law override state law?
Well, federal law would override state law if there were federal law, but as a general principle, there is no federal privacy law. And that's what makes the United States different from a lot of European countries. European countries all have general privacy laws that have enshrined what we would consider to be the common law. Concept of privacy was that if someone has a reasonable expectation of privacy and you intrude into that privacy and you make something public, which they would either expose them to ridicule, or it's something that an ordinary person wouldn't want exposed, then that's a violation of privacy. There's no law like that at the federal level. There are specific laws, like with HIPAA. Everybody, now that COVID is over, everybody got a crash course in HIPAA and what it does and doesn't do. But there are federal laws like that talk about use cases. But when we're talking about drone operations and flying, there really isn't any. And the FAA has taken the position that they're a safety organization. They really don't care about privacy and they want nothing to do with it. And in fact, there was a lawsuit that was filed by people who tried to force the FAA to do a rulemaking on privacy. And the FAA said no, and it went through the courts, and the court said no, you do not have to do privacy. Now, Commerce and some other agencies, they have it technically in their bailiwick to do it. And, we'll talk about maybe that there are some best practices that the federal government is on, but there's no specific federal privacy law.
Perfect. And I did kind of coach that a little bit with federal privacy law to see where we go with it. Mary, would you talk a little bit about maybe how the Fourth Amendment plays in here? And then we'll pop down into some state stuff.
Absolutely. So the Fourth Amendment, which is the protection against unreasonable search and seizure, really only applies to government UAS operations. But what's interesting is that the principle of an individual having this reasonable expectation of privacy, which is a phrase that Mark just used as well, it's become relevant to non-government operations as well, because what we're seeing is that many states, in developing their own privacy framework or otherwise expanding their existing privacy framework to apply to drones, they've been incorporating this same concept of that an individual has a right to be protected against intrusion where they have a reasonable expectation of privacy. So you see a lot of state laws that actually use very similar, if not the same language, even though state torts and state common law actually address different harms than the Fourth Amendment. And what we're seeing increasingly is actually this sort of collision between the Fourth Amendment and the First Amendment in certain cases where, there are First Amendment considerations the need to protect the rights of operators, news gathering operations. In particular, there have been a lot of instances where journalism associations have sued against state laws that they say, prohibit or interfere in their right to free speech under the First Amendment. But there's a conflict here, right, between the freedom of speech and the right to privacy. A great, somewhat recent example is the Texas federal court in Texas striking down a Texas state law that prohibited using drones to conduct surveillance operations, and also prohibited the use of flying drones over certain sort of critical facilities under state law, which interestingly in Texas includes feedlots. So it became a huge issue for the farmers associations. Ultimately, they were successful in having the law struck down, sort of because of this juxtaposition between the First Amendment and the Fourth Amendment in these cases. And I think there are a lot of folks out there who really believe that this clash may be one of the greatest impediments to more fulsome integration to the national airspace system and expansion of complex operations. So I think we'll see more of it.
Well, Mary, how does trespass and nuisance kind of fold into that whole state issue when it comes to privacy? Yeah,
that's a great question, and kind of gets to how different states are starting to develop or expand their frameworks. Some states and local governments will, as I mentioned, will use their general privacy laws or their common law causes of action that are not specific to UAS to protect against UAS-related privacy harms. And trespass and nuisance can be an example of that. So in some states, I think Utah is a good example of this. You may have sort of a state and local peeping Tom law, if you will, that's, it can be charged under a general voyeurism law. You have use of a camera where there's reasonable expectation of privacy without that person's knowledge and consent. On the other hand, and this relates to the trespass and nuisance issue, is a common law claim of intrusion upon seclusion, or public disclosure of private facts, which gets to kind of the data privacy issues. And these would be tort-related claims. And then, of course, you have some states who decide to sort of go whole hog, if you will, and develop a new statutory privacy framework that can include drones. And that a good example of that would be California, which I think we'll get into in more detail on this panel.
Which brings us to California in more detail. Mark, you want to? We have the CCPA Act in California, and there are 6 other states that are either have it or working on it. Kenji wants to put the lawyer hat on for a minute. Tell us all about it.
So for your clients, HIPAA was mentioned, and that's really an important thing because, for example, if you have a client that's a hospital that hires somebody who's operating a drone, HIPAA becomes implicated. So if, for example, patients aren't made aware of a drone flying outside their window, there could be a HIPAA violation. So be very careful when advising those types of clients. Hey, you could be exposing yourself to liability. Make sure that you let all the patients know in the building that there will be a drone, and if they wish to close their shades or something like that, operationally, that is really a good way to sort of take care of that issue. So it's not only the legal theory and the statutes that we have to deal with, but it's on the ground operationally in how we advise our clients. So just keep that in mind.
Perfect. I flew a hospital here in Denver. I'm from Denver, by the way, so welcome to Colorado. And I had to stay a certain distance away because it would have been weird. Another issue we have at the state level is law enforcement rules versus private property or private individual rules, warrants, etc., exigential circumstances. Who would like to take a stab at that one?
Feel like I get set up for that. So yeah, that's a tough question because you're dealing between the first and the fourth. What I can maybe do is just speak to a little bit of experience that we had. We had a sheriff's department in the upper Northeast ask us to enable their drones to be able to measure social distancing and mask wearing during COVID. And they had a big issue. They were trying to get data. Was their public service announcements working? Did they have to deploy resources in different areas, et cetera? And so we did that. We built some software, some machine vision software that could determine not only if they had masks on or if they were socially distancing, but we used some data stats and some AI to determine, are they family members? Are they a couple, right? Or are they two strangers that are meeting? Because if they're a family and they're together, that would skew the stats. And so we deployed that successfully. And then one of the officers, she kind of said, well, that's kind of cool, but what would really be cool is if you could detect COVID-19. So within about 9 months, we commercially deployed the ability for our drones to be able to read heart rate, respiratory rate, heart rate variability, blood oxygen level, all via the camera, and deployed it on a pilot, and not fully commercially. And the data we got was fantastic. But man, that was a storm of privacy that came up. So we had when you think about a search and rescue situation now, or when we're triaging these situations in battle zones or emergency situations, when you can use that type of technology, are you invading privacy when you're actually, working to save people's lives, right? Or for the greater good. So I'm not going to pretend to be the lawyer. I'm the operator and kind of the product development guy. And so, I'm all for technology and being able to use it in that. And, but working out the construct of actually how that works in privacy is a big issue. And so I guess those are some of the issues that, now we're starting to look at, because not necessarily because of the drone, but because of the other capabilities that the drones can bring into society.
Well, that definitely brings us to the next, actually jumps 2 feet in with the next privacy and modern tech we're going to talk about. And we had the Long Lake Township versus Maxim. Some of y'all may have heard of that. It was a warranting issue. Mary Caitlin, what's the state-by-state approach on this? Or is there one?
Sure. Well, I mean, I'll give sort of a high-level overview of Maxim for those who aren't super familiar with it. But essentially, the Long Lake Township in Michigan hired a drone company to take pictures of an individual's property, basically to establish that they were using their property illegally as an illegal salvage yard. The township then filed a civil action against the individuals, Maxims, and used photos that they had gathered using the drones as evidence that they were maintaining this illegal salvage yard. Maxim moved to suppress the use of that evidence as a violation of the Fourth Amendment. The trial court denied the motion, finding that they didn't have a reasonable expectation of privacy in that space. So again, kind of come back to that, the general, the phraseology that they use in the Fourth Amendment, the reasonable expectation of privacy. The State Court of Appeals then found that there was a reasonable expectation of privacy and that the government needed a warrant. So where we've ended up is that it made its way all the way up to the Michigan State Supreme Court. And the Michigan State Supreme Court ultimately remanded it back to the lower court, finding that the issue wasn't really so much focused on the Fourth Amendment, but the issue was whether the government should be able to use the evidence obtained from an unlawful search in a civil enforcement proceeding, despite a potential Fourth Amendment violation. So the Supreme Court really assumed that assuming there is a Fourth Amendment violation, what now? Should the government still be able to use that evidence or not? And I leave if anyone else wants to add anything on that case.
Yeah, the interesting thing about it, particularly for those of us who aren't in law enforcement, is when you read the Court of Appeals decision, it looked at the history of police using aerial vehicles to collect evidence. And they looked at, the Supreme Court back in the either late 70s or early 80s said, an airplane flying at 500 feet where it's legally allowed to do taking pictures of marijuana fields, you don't have a reasonable expectation of privacy if a plane is flying over your fields at 500 feet. And then the Court of Appeals looked at it and said, a couple of years later, the same issue came up with helicopters flying at 350 feet. And a helicopter has a right to be lower. Does that make a difference? And the Supreme Court said, no, the helicopter has a legal right to be there. You don't have a reasonable expectation of privacy. But the Court of Appeals looked at it and said, basically, just because technology continues to develop doesn't mean people consent to have their privacy eroded more and more. And they said that drones are just something different from manned airplanes. They're smaller, they're harder to see, they make less noise, they can fly at lower altitudes. And so we're going to treat them differently, even though conceptually there's no difference because the drone has a legal right to be between the ground and 400 feet over someone's property. And so that's the interesting thing is if that line of decision, if that's picked up other places, it means that even though you're legally flying, homeowners may start to have a privacy interest in just the fact that you're flying over their property and filming it.
Do you see that as a civil or a criminal issue?
Well, it could be the analysis they used applies to civil privacy as well as criminal. So it could easily be because they said you have a reasonable expectation of privacy, and that applies whether the police are doing it or a third party's doing it.
Okay. Let's talk a little bit about infrastructure, particularly about 2209. Maybe explain what that is, and whoever wants to take it. Mark, you got the mic. If you want to run with it, the infrastructure 2209. Go for it. Yeah.
Sure. So 2209 was initially introduced in the FAA Extension Safety and Security Act back in 2016, and it basically required Congress ordered the FAA to establish a process by which applicants could petition the FAA to prohibit operation of drones near specific facilities. And Congress kind of gave examples of what would be acceptable types of critical facilities that could be protected under 2209. Examples they gave were, energy production facilities, transmission, distribution facilities and equipment and chemical facilities, things of that nature. I would say probably narrower in scope than what we're seeing at the state law level, where states kind of continue to add to their statutory definition of critical infrastructure. But the deadline, the initial deadline was January 2017, and nothing happened. And then the section was revived in the 2018 Reauthorization Act. FAA was supposed to have an NPRM on the program by March of 2019. Didn't happen. So this is a provision that's not talked about very often, but I think it's being talked about more because we're starting to see that its failure to come to fruition is becoming, it's more of a frustration in the industry now than it has been previously. So, its failure to move forward has allowed state patchworks to continue to proliferate and allows states to continue to define critical infrastructure very differently. And so, kind of depending on what side of the state line you're conducting your operations on, you have to do a completely separate legal analysis of, what the operational environment is like and how they define critical infrastructure and whether operations are limited or prohibited entirely. And so, I think the big question is whether it's going to be revived in the upcoming 2023 reauthorization. I think it's likely that it will, because I think that, stakeholders are going to the Hill regarding their frustration about the FAA's failure to act here. And understandably, the FAA has, a lot to implement and a lot on its plate. But I think, even if it comes back around this year in the reauth, I think based on the history, it's anybody's guess when we'll actually see an NPRM on this.
Kenji's go for it. He's like,
I'm chomping at the bit.
you are.
Now, but what's interesting is if you look at a lot of state statutes, there's one in particular in Florida that deals with critical infrastructure. It is specifically tied to Section 2209, and it's supposed to sunset with 2209. So when you look at your state legislatures in critical infrastructure statutes, just take a look at that as well. One of the things that isn't talked about is the reason I think that 2209 has been delayed so long is it all sounds real good, real nice, but when it comes down to implementation, it becomes very, very, very difficult for the FAA. Because when you talk about transmission lines, when you talk about critical infrastructure, what does that entail? For example, if you think about it, are transmission lines for electricity that go by your house considered critical infrastructure? Think about substations. They are all over the place. If we had every single substation in the U.S. suddenly become, in essence, a no-fly zone, that's going to restrict operations, not only for the small UAS operator, but for the larger pieces, for example, the beyond visual line of sight, the inspections, everything like that is going to be impacted. So what I think you're seeing is the FAA taking a very slow approach and being very careful so they don't inadvertently in essence, create huge areas of land or air where we cannot fly. So that's my 2 cents on that.
Perfect. Well, 2209 was originally set up, obviously, by, has DHS fingerprints all over it for security issues, but it is a privacy issue as well. And we address that, I think, pretty well. Since you have the mic, Kenji, Yep. Video capture examples of how privacy plays a role.
Oh, absolutely. So if you think about it, so this is more from an operational level. That's the world that I come from. So it's not only the statutory authority and the jurisprudence, but how does that translate into work on the ground? So from my perspective, it is, for example, if you take video of somebody and you capture it and you're doing it for a commercial, you're going to need releases. Otherwise, you can be fined civilly, or that somebody could file a civil lawsuit against you for that. Another one is, say, for example, you are flying around taking pictures of real estate. You really want to take that into consideration because there are some elements of copyright law involved in some buildings. For example, another one is the Hollywood sign. There's elements of that as well. But privacy, it becomes an issue when you're taking video of people you don't know or you don't have permission from. So there's that civil litigation outlet that a lot of people might have. So when you're dealing with your operators, always have that in the back of your mind when you're helping them create SOPs, standard operating procedures and such, just to take that into consideration that you might be capturing people who might not want to have their likeness out in the world. So there's that implication. And I think from an operator perspective, that pretty much is the biggest aspect that I have to deal with on a daily basis. Fortunately for me, I work on large video shoots, for example, movies, etc., and they get model releases from everybody, and they also restrict access. So for me, it's not a big deal, but for small operators who don't have that luxury, definitely talk to them about capturing folks that you might not want to have captured, or they don't want to have captured.
Cam brought up a kind of a scary scenario that's a reality with AI and biometrics and stuff like that with drones. Hold on. He mentioned that it brought up some interesting laws, but then didn't touch on them. So I'm going to give Mark and Mary Caitlin the opportunity to dive into that.
Yeah, I think right now we're seeing the dam is breaking on biometric protection laws. Illinois, I think, has the most stringent one right now. It passed a couple of years ago, and it was the first one that gave people a private right of action if their biometric data was improperly released. And it was negligently released, and $5,000 if it was done intentionally. And that's for each release. So a good example, BNSF got hit with a $227 million class action because each time someone's data was given out, it was $1,000 or $5,000. And so that multiplies quickly. And just this year, there are over 12 states that have basically looked at enacting laws very similar to that. Like Hawaii has one. They're proposed. Anytime you collect someone's biometric data, you have to disclose that you're going to collect it from the person. You have to tell them how you're going to store the information, how long you're going to store the information. You have to get their consent. You're not allowed to profit from the biometric data. And I forget what the fifth one is, but there's some criminal or civil liability, again, if you improperly diminish it. And part of the problem is you're going to see a real patchwork because, again, like Hawaii says, you can hold the biometric data for however long you want, but you got to tell the person in advance. Other states' laws say you can only hold the data for 2 years, or you can only hold the data for 3 years. So you're complying with your law in one state, and now you've decided you're going to go over and you're going to do a mission, you're going to collect data from someone, facial recognition, biometric data in another state. Your standard operating procedure might be violating that law, which may apply because that's the state where you're collecting the data, and you're collecting the data from people who are residents in that state. So this is something that's going to become, I think, a real headache going forward over the next couple of years.
And I think this is a great opportunity to circle back on the CCPA, the law in California that addresses data privacy. I mean, this is the most expansive consumer privacy legislation in U.S. history, essentially. And a lot of people believe that it's sufficiently broad to protect UAS collected personal information, to include biometric information such as faces, audio recordings, visual recordings, thermal data. It really runs the gamut of anything that could be collected on an individual. And personal information is defined really broadly. I believe it includes, information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular resident or household. So, I mean, it's just incredibly expansive, and it imposes these obligations on entities that do significant business in California, that collect residents' personal information, including purchases, rentals, receipts, access, or otherwise. So, kind of adding on Mark's point about the patchwork quilt, when you add the CCPA into the mix, you really don't have to have much of a nexus to California or to its residents to fall under the purview of this law.
You bring up, both of y'all are bringing up how different state laws are. So you've got Hawaii on one extreme, and you've got half the other states in the country that don't have anything. And this is off the cuff. So here we go. We started off by saying there's no such thing as federal privacy law. Would that help if we put one out? And would it hurt? Whoever.
Well, I'll start. I think, the big question about laws like CCPA are, will it be preempted if Congress enacts federal consumer data privacy legislation? I think the answer is probably yes. So to the extent that there is some kind of all-encompassing, federal level legislation that covers the same subject matter as these patchwork state privacy laws, I think that they could be preempted. On the one hand, that could be a good thing for a lot of operators who have, expended a lot of resources and time and energy in trying to comply with a myriad of different, legal frameworks. But I think, I think that any type of federal legislation could be subject to a wide array of challenges, and we might still be a ways away from, really having any resolution to that question if if Congress were to legislate in this area.
Yeah, and I think one of the other issues, when you have anytime you get the feds involved, is there has to be a national consensus, obviously, to move in a particular direction. And that's really, in this climate, it's really hard to get everybody to agree that there's a one standard that's going to fit all. So I think to a certain extent, there's that pressure. And then the other pressure is there are a lot of entities which have a lot of money that they spread around in Congress, which really want it to be a more open playing field when it comes to using people's data and people's biometric data. So they would not prefer to have a federal standard unless it was something that was very relaxed, that they could take advantage of, in a way to continue to do business the way they're doing. So I think that kind of mitigates away from, a standard, getting the federal government to do something about it. But the other thing is, there are, in situations like this, there's, the Uniform Rules and Uniform Laws Committee. So we could wind up with somebody proposing a Uniform Biometric Data Act, which then would be enacted by various states. We have a Uniform Commercial Code, Uniform Wills and Trusts laws. They are actually pretty active, and they are pretty successful when they put their minds to it.
Go ahead.
Okay, thank you. So there is something fairly interesting. I'm jumping ahead just a little bit to NTIA best practices recommendations.
You're jumping ahead a lot, but go ahead.
One of the recommendations was, of course, that you have a privacy policy, and that's in there. But what was subsequently very interesting is that in the FAA Reauthorization Act of 2018. Under Section 375 of the Act, it is an unfair and deceptive practice under FTC Act 5A for a person that uses an unmanned aircraft system for commercial purposes in the national airspace system to violate a privacy policy. So it is exactly. If you do have one, do not violate that. And along that lines of that national sort of standard, it's noted that it was the sense of Congress to have a privacy policy, but it was not required, which was fairly interesting in that. And I think that has to do with sort of the lobbying efforts of a lot of different stakeholders and a lot of competing ideas too, and seeing both sides of the issue. And I think that's why it happened. But what it boils down to, it's not mandatory, but if you do have one, you best not break it.
Which brings us actually to the previous slide that we passed up. Ramifications for failure to protect. Let's start with Mark on this one. I'm going to give Cam here in just a second. Don't worry about it.
Well, I mean, obviously the ramifications, the biggest ones are civil liability. It's, as we talked about with the biometric law. I mean, you're talking about about the enterprise liability if you screw it up. $100 million class action is going to put you out of business unless you're, some kind of a giant corporation who has very deep pockets. So, I mean, in that regard, that's why it's very important to have a policy. Because here's the thing: if you violate someone's privacy, and then you go to court, the person sues you, and they ask you, well, what did you do to protect my data? What was your privacy policy? And your answer is, I don't have a privacy policy. Then the jury is going to look at you, and you're going to lose the case because you really did nothing. And even then, when you're talking about NTIA, NTIA is a industry best practices, but when you get to things like that, it's almost like that becomes the floor rather than the ceiling. I mean, nobody flew here to be here today on an airline that said, we meet all minimum federal safety requirements. It's like, nobody's going to get on that airline. So in a way, that really does become the floor, because either from a competitive standpoint, you want to distinguish yourself from your competitors by saying we hold ourselves to a higher standard. But more importantly, if you screw up, you have a higher standard that you can fall back on. Say, look, we had this high standard. It didn't work in this case, but we're really trying. And as a result, we weren't negligent.
Go for it. I'm going to ask you something after that, though, McKinnon.
Okay, well, I want to add to Mark's point that it's also really important to look at your customer contracts, because kind of outside the world of common law or state law liability, you could have contractual liability as well to your customers. And then there's, of course, the possibility and likely probability, in fact, of reputational harm. There hasn't, I think that, in a lot of scenarios, regulators and state governments are kind of looking to make an example, where, these issues are kind of coming to a head. And, if something were to happen, if there's a privacy issue, I think those are cases that are making headlines, at least, within our industry at this point. And so, it's very possible that there could be some significant reputational harm done, if you were to run afoul of a privacy policy or a state privacy law.
Mark brought up not having a privacy policy. Which is worse? And I'm asking for some free legal advice here, so you get what you pay for. Not having one or having one and not following it? And anybody can take that or pass on it.
Yeah, I would say not having one in a lot of ways is worse than not having one, or than having one and not following it. Because, I mean, everybody makes mistakes. There's liability. The federal aviation regulations are there, to keep people safe. And you say, well, is it better to not follow the regulations or to say I'm following the regulations but then violate it? If everybody did what they were supposed to, there would never be any accidents and nobody would ever be liable. So at a minimum, having a policy that's thought out that everybody in the company is supposed to follow. I mean, that you have to have that as the basis, because if your employees are in a position where they literally do whatever they want because there's no policy, you're really exposing yourself. And I said, if you're in front of a jury, because I'm looking at it from the jury perspective, you don't want to be there arguing that we don't have a policy and we let everybody do what they want, because nobody's going to respect that as the answer. But saying we have a policy, we have a manager, and the responsible manager is supposed to do this, and in this case they screwed up. But that's not our policy. At least even if you've done something and you're negligent and you're going to have to pay compensatory damages, at least you're not exposing yourself to punitive damages because you're being willful or wanton or reckless and you just don't care.
And give it to Cam. Just pass it right by Kenji. There you go.
I got something to say.
You'll get something to say in a minute, I promise you. As far as the ramifications go, from a practical business impact, what can that be? And Mark touched on it a little bit. What can that impact be to a business?
In terms of the policy?
Yeah.
Yeah, well, for sure, having a policy.
Failure should protect the policy. Yeah. Failure to protect privacy, sorry.
Well, it's catastrophic. Yeah, I mean, absolutely catastrophic. In the example that I was speaking to earlier, even though we were in a very, kind of closed environment and we had done all the disclosure and all of those types of things, I mean, several members of the town council and the police chief had their jobs on the line, right? And we had considerable potential reputational damage to deal with, even though we followed that. But if we hadn't had those and put those things in place, it would have been catastrophic. And, I think policy does a lot of things. beyond just protecting you. It actually, it really actually sets your culture as well. And so, from an operational standpoint, not just from a liability standpoint, having those things in place, being able to bring people on to see that you've thought those things through, or that you're making the best attempt, or that they're working with or for an organization that thinks or cares about those types of things. Because if you're if you're an organization that's reckless about privacy, for your customers, whether they be a consumer or another business, you're likely reckless about your privacy for your employees as well. And so I think culturally, those types of things are incredibly important.
Okay, Kenji.
So conceptually, privacy policies are a very good thing. But one of the things you want to also take into consideration is the sophistication of your operation. Say, for example, at the highest level, you're doing very complex operations. You are doing drone delivery that has a high impact on neighborhoods. You're flying over neighborhoods. People are going to see it. They're going to know when you're around. You're going to you should have a robust privacy policy. So people can look at your website and go, these are sort of the things data that we collect. This is what we're going to do with it, or this is how we're going to protect it. And if something happens, what are we going to do to rectify it? So that's on the really large side. Going to medium size, you have to right size your privacy policy. Because if you think about it, we're lawyers. We think about risk. And then also not only risk, but likelihood. So if you're a very small operator that's doing like once every couple of weeks or once every couple of months, like you're popping up, taking a photo or whatever, unless you're doing something really dumb, I mean, the risk is very, very low. So do you need a privacy policy? Maybe. But is it absolutely necessary? Probably not. So just thinking about scale and appropriateness of the level of privacy policy, or even if it's needed as well.
Okay, quick popcorn round, 15 seconds each, conclusion. And then we'll open up to Q&A. I know, 15 seconds, sorry.
Well, in conclusion, I think the construct is in place, and I think we have a society that really has healthy competing interests to push the commercial aspects forward, but also to protect privacy. And what we're seeing is we're seeing all of those things being tested with different use cases, because we've got new sensors and new type of, orientated in different spaces, like not necessarily from your phone, but, from 400 feet above your house or above a piece of infrastructure that's close. So I think we just got to grind through it, and just the more we can address it head on, the better. And I do, with Kenji's opening statement, where we have to do our best at this, and we have to really, really be overt about it. I think that's going to be the only way that eventually society is going to get comfortable with this.
All right, my 15 seconds. My biggest advice is tell your clients not to fly like jerks, to be honest. That's what it really boils down to. The NTAIA comes up with some great recommendations in terms of inform others of your drone use. Show care when operating UAS or collecting stored covered data. Limit use and sharing of covered data. Secure covered data. Monitor and comply with evolving federal, state, and local UAS laws. So just pay attention. Pay attention. Have your clients pay attention. And again, please don't let them fly like jerks.
I think one of the biggest things to remember, nobody wants to talk about it because it's boring, but the key tools you have as a businessman to manage risk is contracts and insurance. So don't neglect those two, particularly contracts. Contracts can be used to spread around liability and to make sure everybody knows who's collecting data, who owns the data, how is the data stored, who's responsible for a breach. If there is a breach, are you going to pay me for your negligence? That's where all that stuff has to be, is in your contracts, and that's the best way to protect yourself.
I would say know the extent of your operation, right? Know what your touch points are, because they might be more extensive than you might think that they are. So your touch points with any one of these state and local privacy laws, may be broader than you're thinking. So know what your touch points are, know where your data is being stored and how long it's being stored for. And know your laws, where your operations physically take place and where your other touch points are, and be aware that Some relevant state and local laws are not located where you think they might be. For example, some states have very specific laws that prohibit drone operations on state university property. And those laws are sort of hidden deep in the laws that relate to, administration for public universities. So it can be tricky in locating these laws. So, give yourself time, when you're scoping out locations for operations to really dig in and understand what the potential exposure could be.
Questions? Yes, sir. This will be good.
Question. Comments, Draganfly, keep doing what you're doing and innovating. Your biometric stuff is amazing. Your promo drone production is amazing. And that's why you're my favorite type of stuff.
Woohoo! Yeah! All right.
I did not pay him to say that. But my question is, it's ironic that we mentioned Europe as being privacy when there's CCTVs on the island and all over the continent. But how do we distinguish between me being able to take a movie anytime I want on the street, and nobody can smack that phone out of my hand, and they can't make me delete it? Why is that different than the dashboard cam on a truck, on a Swift truck, or
Swift.
nut trucking? And why is that different from the one in my daughter's car? Or why is that different from the one in a drone?
Yeah, that's
Well, it shouldn't be different, but to a certain extent it is. And one of the other things to keep in mind is, you talk about taking your phone out and filming people on the street. There are states where that actually is not legal. They're on the statute. In Maryland is a two-party consent law. If you film someone on the street, in theory, you are violating their privacy, and you have to get two-party consent. And the police do use that to stop people from filming sometimes on the street. Now, I don't think it would stand up if it really went, all the way up to the Maryland Supreme Court. It's not gonna stand, but those laws are still out there.
The dash cams?
Yeah, I know it doesn't really make any sense. It's different because it's drones. That's why it's different.
I got the 2-minute warning from Don. Any more questions?
Yeah.
Does videotaping people's faces implicate these biometric data laws? Pretty much not using it for like facial recognition, or it's only if you're like measuring people's faces for facial recognition?
Can you repeat that?
I think it depends, again, on the state law and how the biometric data is defined. For most of the states, when they talk about biometric data, they're talking about the data that turns the image into an identification of someone. So that's the biometric data. The picture itself, not necessarily. But if the picture is used as part of a training, to get it to be able to recognize someone, that potentially could be biometric data. But again, it depends on what you're using it for. If you're just taking a picture of a person on the street and you're not using it that way, then it wouldn't be biometric data. But like retinas and stuff like that, though, it is biometric data.
Well, I got one question then. Maryland's a two-party state. Do they not have red light cameras and speeding cameras?
They do, but it's different because the state does it. So
We'll get that passed here in Colorado.
All right.
Good. All right. Thank you, everybody. Thanks to the panel for coming, and thank you all.